Welcome to the Deep Dive. We're here to get you smart, fast, on the topics you really need to understand.
And without drowning you in information.
Exactly.
Mhm.
So today we're unpacking global copyright. It's this huge topic in our super connected world.
Yeah, and let's be honest, the phrase international copyright itself sounds kind of intimidating, doesn't it?
It really does, like wading into some deep legal waters.
That feeling is totally normal. We're dealing with something where, protecting creative work across borders, there's no single simple answer.
Right. And for this deep dive, we've looked at some really interesting stuff. Articles from copyright groups, legal breakdowns like Wikipedia on the Berne Convention, news reports on big copyright cases.
And even discussions from online communities, people actually dealing with this stuff day to day.
Our mission here is to pull out the absolute must-knows about international copyright. Make it clear, make it relevant.
Yeah, whether you're creating content, maybe running a business, or honestly just curious about how these rights work when things go global.
We're aiming for those light bulb moments, those aha insights that cut through the confusion.
Okay, so where do we start? I think the fundamental problem needs tackling first.
Agreed. And it's a big one.
Yeah.
There is no single unified international copyright law.
That's the absolute core of the complexity, isn't it? Unlike, say, international trade, maybe, where you have these big, overarching agreements.
Copyright's different. It's more like a patchwork quilt.
That's a great way to put it. A quilt sewn from different bits. You've got international treaties, the Berne Convention being the main one we'll talk about.
Okay.
But these treaties, they don't just create one global law. They set minimum standards.
The minimum standards. Right.
That member countries then have to build into their own national copyright laws.
Ah, I see. So national laws are still key.
Absolutely. Then you layer on things like licenses, specific permissions from copyright holders, and even company policies on how they handle copyrighted stuff.
So all these layers interacting. That's what makes it so complicated if you're sharing or using content across borders.
Precisely. You can't just assume what flies in your country is okay everywhere else.
Yeah, that's a crucial takeaway right there.
And think about the scale. We found this stat. It's something like 3 billion images shared online daily.
3 billion. Wow.
And get this, maybe 85% of those could be infringing on copyright. Stolen,
So
basically.
85%.
Wow.
That's staggering. It really shows you the practical side of this complexity.
It really does.
Okay, so if there's no single global law, what is the main international agreement? You mentioned Berne.
Yes, the Berne Convention. Its full name is the Berne Convention for the Protection of Literary and Artistic Works. It's really the foundation.
Okay.
It dates way back to 1886. Victor Hugo is actually one of the people pushing for it.
No kidding.
Yeah. And the core idea is this. Creative works from any member country, and there were 181 member states as of late 2022, so it's huge. Get automatic copyright protection in all the other member countries.
Automatic protection. Okay,
Yeah.
let's unpack that. What does automatic really mean here?
It means protection kicks in without needing formal registration or jumping through bureaucratic hoops in every single member country.
So no need to file paperwork everywhere.
Exactly. The convention actually forbids making registration mandatory for protection. It's a key principle.
That's interesting.
And there was this U.S. case, Moberg v. Leagues, mentioned on the Wikipedia page. Even though the U.S. used to link some remedies to registration,
Right.
this 2009 ruling basically said, nope, for works from other Berne countries, you can't demand registration for basic copyright protection.
So Berne pretty much guarantees that if you're protected at home, you're protected in most other places too. That simplifies things a bit.
It simplifies the initial step, definitely.
So who exactly gets this protection under Berne? Is it just authors?
Well, Article 3 says it covers nationals and residents of member countries. And it also covers works first published in a member country.
First published.
Or published simultaneously. That means within 30 days in a member country. Article 4 adds specifics for films, based on the producer's base, and architectural works located in a member country.
Okay, what if something comes out in multiple countries around the same time? That sounds like it could get confusing.
It can. The convention talks about the country of origin to figure out which country's rules might apply in some cases. Normally, if it's published in just one member country, that's easy. That's the country of origin.
Makes sense.
But Article 5.4 deals with that simultaneous publication issue within 30 days in several member countries.
Right.
In that situation, the country of origin is the member country that gives the shortest period of copyright protection.
Shortest term. Huh. That's an odd rule. Why shortest?
It's a specific mechanism within the treaty, often called the rule of the shorter term. It aims to prevent authors from gaining longer protection internationally than they would get in the country, providing the least protection among those where it was simultaneously published.
Okay. And what if it's published in, say, one member country and one non-member country at the same time?
Then the member country is deemed the country of origin.
Got it.
And for unpublished works, or things first published outside the Berne network, without that simultaneous release inside, well, then the author's nationality usually determines the country of origin if they're from a member state.
Okay.
Again, with special rules for films and buildings based on where they're made or located. Think of country of origin as like the work's first passport in the international copyright system.
Good analogy. Okay, so Bavern covers who gets protection and where. What about what gets protected? What rights are guaranteed?
Article 2.1 is pretty sweeping. It covers every production in the literary, scientific, and artistic domain, whatever the mode or form of its expression.
So very broad.
Very. Then it lists minimum exclusive rights that countries have to recognize. Things like the right to translate your work, to make adaptations or arrangements, perform it publicly, broadcast it.
Broadcasting feels huge today.
Oh, absolutely. Also, the right to reproduce the work in any form, though there are some exceptions allowed there as long as they don't mess with the normal use of the work or hurt the author's interests too much.
Okay.
And importantly, the right to use the work as the basis for a movie or other audiovisual work, and then control that audiovisual work too, reproducing it, showing it, etc.
It's quite a list. Seems like a solid foundation. But you said Byrne started way back when. Has it kept up with, the internet and digital stuff?
That's the sticking point. It was revised several times up until 1971, trying to adapt.
Okay, 1971.
But as the sources point out, there have been no major substantive revisions since then. The core rules were basically set before the digital explosion.
Wow, since 71. Why so long with no updates? That seems problematic.
The main reason is the structure of the treaty itself. Every single one of the 181 member states basically has veto power over big changes.
So getting everyone to agree is nearly impossible.
Exactly. With so many countries, all with different interests and levels of development, reaching consensus on updates for the digital age, it's proven incredibly tough. Some experts even think more major revisions are just unlikely. So this stagnation, it's a real issue. It means the international framework sometimes feels pretty outdated compared to how we actually create and share stuff now.
So Byrne is vital, but maybe struggling to keep pace. Okay, let's shift gears a bit. Talk about fair use or fair dealing. How do those fit in?
Right, so fair use, you mainly see that in the US. And Korea has something similar in fair dealing, which you find in places like India and Canada. These are basically exceptions within national copyright laws.
Exceptions, meaning?
Meaning they allow limited use of copyrighted material without needing the owner's permission.
Okay. For specific reasons.
Yes, typically for things like criticism, commentary, news reporting, teaching, scholarship, or research. The idea is to balance the creator's rights with the public's interest in accessing and building upon information and culture.
I know in the U.S., fair use is notoriously decided case by case. It's not a simple checklist.
Definitely not. U.S. courts look at 4 main factors.
Okay, where are they?
1, the purpose and character of the use. Is it commercial? Is it nonprofit? And importantly, is it transformative? Does it add something new, a new meaning or message?
Transformative, okay.
2, the nature of the original copyrighted work. Is it highly creative or more factual?
Right.
3, the amount and substantiality of the portion used. Did you copy the whole thing or just a small necessary bit? Did you take the heart of the work? And 4, the effect of your use on the potential market for or value of the original work.